You'll tell us when you let people in, right?
Yep. I just figured there's so much going on in the beginning. I don't want to forget to record it. I can trim it, so it's not a big deal. So yeah, I will start to let people in. So there's no last minute questions, correct?
No. Glasses.
Okay, so I'm going to start to let people in. They will be able to hear you, so just be mindful of any noises that you're making, shuffling papers and stuff. And we can also see you cleaning your glasses and stuff like that. So
You cleaning my glasses right now?
yeah, so I'll just wait till you're done.
But you can't see right now, right?
I can see you.
You see my glasses?
No, but I saw you cleaning them, so I didn't want to bring you.
Okay.
Okay,
Yeah.
all right. So I'm going to start to let people in, and then Leslie, as I'm talking, you're going to keep letting people in. You're going to just keep hitting admit all, like you've done in the past.
Will do.
Okay,
All right.
awesome.
Okay, good luck, everybody.
All right, have fun. And don't forget, we'll do the wrap-up call too,
Okay.
afterwards. So hello and welcome. My name is Patty Murray and I will be your host and moderator for today's peer-to-peer webinar, presented by FamilyKind, a nonprofit organization that empowers children, parents, and couples before, during, and after separation or divorce. FamilyKind offers mediation services to families on a sliding scale fee. We are able to bring you this webinar series for professionals free of charge because of the generosity of our two sponsors, SoberLink and Our Family Wizard. SoberLink supports accountability for sobriety and child safety, combining a breathalyzer with facial recognition and wireless connectivity for real-time results and reports. SoberLink's new Family Assistance Program offers alcohol monitoring free of charge to anyone who qualifies. By increasing our total reach in our mission of supporting families affected by alcohol abuse, this program will help continue to reduce litigation and foster peace of mind. Our Family Wizard is a comprehensive app that enables you to conduct all your co-parenting communication on a single platform. Powerful tools document your parenting time, reimbursement requests, payments, exchanges, and more. This means less conflict and more energy to focus on your children. So today's webinar is entitled Mediating with Attorneys in the Room, a Mediator's Perspective. And we are going to learn from two professionals who have their own practices and are FamilyKind mediators. Helene Bernstein is an attorney representing adults and children in the Family Supreme and Appellate Courts. After representing many children in high conflict custody and divorce cases, Helene trained as a divorce mediator and collaborative attorney in order to improve outcomes for families and provide options outside of the courtroom. Helene has been appointed as a mediator for the Kings and New York County Supreme Court presumptive divorce mediation panels. Helene graduated with a JD from Brooklyn Law School and a BA from Binghamton University. Andrea Hirshman is a family mediator and collaborative law attorney. After learning the limitations of litigation, Andrea saw mediation and collaborative law as healthier forums for couples to resolve the challenges they face when ending their marriage. Andrea brings compassion, understanding, and expertise to her work. Andrea has been appointed as a mediator for the Kings and New York County Supreme Court presumptive divorce mediation panels. She received her BA from SUNY Buffalo and her JD from CUNY Law School. Also joining us is Leslie Friedland, Executive Director of FamilyKind, who would like to start us off with some opening comments. Leslie?
Thanks so much, Patty. Good afternoon, everybody, and thank you all for being with us today. I would particularly like to thank Helene, Andrea, and Patty for their work on this excellent program. I'm excited about this topic because, as many of you know, the courts have launched a new initiative involving divorce mediation. This is terrific in many ways, but does come with challenges. One of the challenges is the fact that the court is asking that lawyers be involved in the mediation room. Many mediators have not done any or have done very few mediation cases with attorneys present in the room. That is why I'm so glad to be here with two seasoned professionals who have private mediation and legal consulting practices, as well as serving on the FamilyKind mediation panel. Today, they will share their experiences, give us tips and tools to help us handle the court-referred mediation cases with a spotlight on how to handle attorney participation in this process. Without further ado, I'll give you Andrea Hirshman. Thank you.
Andrea.
Andrea, we're not hearing you.
Sorry about that. I was just welcoming everybody and thanking Leslie and Patty. And, now that the court has embraced mediation to benefit families and that they are referring cases to mediation, some attorneys, even mediators, participants may be unfamiliar with what the roles are of each participating party. So this overview tells you pretty much what we're going to tell you, what the different roles are. So I'm just going to move to the next slide and get right into what is the attorney's role in mediation. So in a nutshell, to empower the client. So when you're representing a client, an attorney representing a client, in litigation, it's a little bit different than in mediation. In litigation, it's more of, as this slide says, you're standing in the shoes of your client. And so you do all the talking for the most part to the judge. The judge talks to you. You do you answer for the client. But in mediation, the clients do most of the talking. So what do the attorneys have to do to empower the clients to be able to stand up for themselves? So, well, with the attorney's help, the attorneys try to help the clients identify what's important to them, what are their underlying concerns and their interests. Certainly the attorneys will counsel the clients about the law, what their rights are under the law, but they will focus more on the historical role of attorneys, which originated as being healers of the breaches in the social fabric of life, and settling conflicts and helping to resolve and heal, as opposed to, sometimes the adversarial nature can just heat things up. So, so you're supporting your clients to find solutions, and the attorneys are also helping to brainstorm options, spending time exchanging ideas and putting them out there, and ensuring your client has a meaningful opportunity to make informed decisions. So that the key thing is really that your client knows what the law is, but maybe they'll make a decision that doesn't comport with the law. And your job is to make sure that they understand the law, they understand they're deviating, and even if you don't agree with their sense of fairness, it doesn't comport with your sense of fairness, that you support what they want. And that's one of the key things as the attorney. So, so making sure your client's decisions are informed and they can speak up. The last thing I want to say is that also that they participate in good faith, meaning that they provide all necessary information, and also that they consider options that aren't just going to work for them, but are going to also work for the other party. Otherwise, we'll never get across the finish line. So.
Thanks, Andrea. So the concept of empowering our clients is really the key to a successful mediation. Wouldn't you agree?
Yes.
Yes. So it's such a thrill to be sitting here on the webinar with Andrea. I started my mediation career sitting in the same room as Andrea Hirshman back over 10 years ago with Community Mediation Services. And I was so thrilled to know that there was another option for families out there in terms of taking control of their lives. And mediation is often the key for many of our clients. And I'm also so thrilled to be sitting here as a consulting mediator for FamilyKind. Leslie and I had this idea about creating a mediation program, and it's really blossomed. It's a wonderful program for everybody to explore. And I'm also sitting on the advisory board, and we're always creating new opportunities for families who are going through separation and divorce. So the most important person in the room is our clients, the participants. So what exactly is their role? They need to know that they have the opportunity to create their own agreements without having a judge tell them what's right for them and their families. And so how do we do that? The mediator is going to help this participant identify their goals and understand that they're the guardian of the outcome, like our slide states. That they also understand that this is a confidential process for them. And so that way they could feel free to explore their needs, their interests without worrying that it's going to get back to a judge or backfire on them. The participant not only has the opportunity to share their point of view and their interests, but they have to also understand they have to sit and listen to their spouse's point of view, which the mediator helps them do by what's called looping. Because although you don't have to necessarily agree with your spouse, you have to understand their point of view in order to gain trust and build understandings, which hopefully will allow us to help our clients create agreements. Andrea, do you have anything else to share when it comes to the participant's role?
Covered it all. So,
Andrea, I think you're going to then move on to what is the mediator's role. Is that right?
this is true. Yep. So, similar to how an attorney controls the process when the client's in the attorney's office, or a judge controls the process when you're in the courtroom, the mediators control the process when you're in the mediation room. They're the guardian of the process, how it will go. And the key thing is creating a safe space. That is key. To create a place where the parties feel safe expressing their goals, but also what are their underlying concerns? What is it that they're worried about? What is it that they're interested in? And in doing that and creating the safe space, the mediator goes through some of the parameters of a mediation, which is that it is confidential. And the beauty of that is people can say things and not worry that they'll be offered into court against them. So it's more viewed in like the nature of a settlement talk, which wouldn't be admissible in court. And it's a voluntary process, even though the court mandated you there. Once you're there, you can just say, this isn't working, and you can end it. And that's really important because along with the self-determination where the client makes decisions and decides if they still want to participate, it's important because you think they wouldn't agree to something unless they really thought they could carry it out. So it makes for stronger agreements as opposed to sometimes when a judge decides things, somewhat happy is somewhat unhappy, but you can feel like things were shoved down your throat. And you don't get that in mediation. In mediation, you decide. So that's key. Also, the mediator to create a safe space might establish some ground rules. So that depends on the style of the mediator. Some mediators establish it right away, like no interrupting or those kinds of things. Other mediators wait to see what needs to be established, if anything. But there are some rules that need to be established given the remote nature of mediations now, such as, is this being recorded or it can't be recorded and things like that. And also mediators guide the communication so each person feels heard and understood. That's key. And in doing that, the mediator will narrow issues, ask questions, and they'll narrow issues so they can really get at what it is that the person wants. And in so doing that, they can then frame the issue in a way that's collaborative, a collaborative task statement. I'm calling it. It's called that in collaborative law. But anyway, where you say, okay, spouse A, I hear you saying that X is important to you and that's what you want. Spouse B, I see you saying that Y is important to you. That's what you want. So let's brainstorm options now for is there a way that we can find a solution that will take care of X and take care of Y. And our job is to support attorneys in helping us do that and in brainstorming. And the last thing I want to say is we also, mediators can balance inequities. If there's some sort of, someone's very quiet and not speaking up, a mediator can address that and try and pull the person out. And if need be, sometimes an attorney might end up having to talk for someone who is just so disempowered. But the gist is, generally speaking, the clients do the talking, and mediators look, though, for those inequities. So did I leave anything out, Helene?
No, so Andrea, I think it's clear that the mediator is the manager in the room, and you're helping validate everybody's roles and reminding them to stay in their lanes. That you know how to facilitate those conversations and understandings. And you do your job very well, I know from experience. And people feel you're a very good mediator because you have trust in everybody that they can get there as long as they're informed. And the attorneys can help inform those clients in terms of the law. And you can help clients talk about their interests and their needs. So what I'm going to talk about, go ahead.
We're getting some questions about the mediators, the attorneys, and the participants. So somebody's asking for clarification. Does each client have their own attorney in the room, and that the mediator is somebody separate other than the attorneys?
So, okay, you want to answer?
What I was going to say, it's an excellent question. Thank you for asking it. In terms of attorneys, not every client has an attorney. Most clients do, but we often do mediate cases without attorneys in the room. Of course, this presentation today is about attorneys in the room with the clients, but we do have cases, sometimes it could be one-sided. And if everybody's in agreement that a mediation is appropriate in that case, we will mediate those types of cases. Andrea, anything else to share?
Yeah, I was just going to say, what mandated program, presumptive mediation program, the attorneys go to the first mediation session with the clients, and there is the mediator. So there's at least 5 people in the room. But part of the mediator's job that I left out, thanks for reminding me, whoever asked the question, is to show the value of mediation, to show how there's this alternative way of settling this family matter. And oftentimes what ends up happening is the attorneys tell the clients, you can go to the next mediation without me, because they see the value and they see that they're not really needed in the room. And in private mediation, it's more the rarity that there's attorneys in the room. It's usually the mediator and the 2 parties. So there's not a need for the attorneys to be there, but in the court-ordered mediation, they come the first time. And they can continue to come, but then there's that cost that's involved. So,
I'd just like to add, I think those are great points. And just to add to what you're saying is, it also helps demystify, I guess, what goes on in the room. Unfortunately, there's a lot of misconceptions about mediation and things. So I guess a benefit of having the attorneys have to come to at least one session is they see actually what an excellent experience it can be for their clients.
Yes, I agree. And that's where the attorney's role as counselor comes in, because the client is counting on the attorney to counsel them, to say, is this the right process for me? I need legal information and advice so I can be guided as to whether this is the right process. So this is a great segue into what happens next. You're in court, and the court has offered mediation, has a process to perhaps resolve your matter. So we have the assumption here that the court has used their staff to do a screening to see if the parties are compatible for mediation, which includes a very detailed domestic violence screening and protocol. So when the case comes to the mediator, we have that assumption that that was done. And so, you know, this part of the presentation, of course, it depends on the particular mediator and their style as to how they want to introduce themselves to the attorneys and how they want to explain how their particular process works. So in my practice, I send out an email to the attorneys, letting them know that I have been advised by the court that I've been selected as the mediator, and I want to get on a pre-mediation call, just so everybody understands what their role is and how this is all going to roll out. And so I give both of the attorneys an opportunity to share with me where they see the impasses here that are preventing resolution. So a few things that I want to know. I want to know if there's been a preliminary conference. In most instances, that would be the case. I would like to have the preliminary conference order. I want to know what the court has laid out as a roadmap in terms of discovery. I want to know if there's been any temporary orders as to support or maintenance or temporary parenting access orders. It's also important to have a statement of net worth. This is where it's important to note that this process for mediation is a little different than the typical mediation that comes into your office where the clients don't have attorneys. These clients are not coming in with a clean slate. They've made various attempts to try to resolve the case. They've gone through the preliminary conference for the most part. And so now they're at a pinnacle in the case where either they're going to try to resolve it or they may have to get a court involved, meaning through a trial, of course, if mediation doesn't work. So we'll have that conversation on the phone. There's an agreement to mediate that the court requires that the parties and the attorneys sign. It's a very important document because it highlights that mediation is voluntary and that it is confidential and that there's going to be good faith moving forward in terms of sharing information. And so, and it's also important for the attorneys to know what their role is. Again, it's not about legal wrangling. It is not a court conference that most attorneys are accustomed to, where there is a court attorney hearing both sides, perhaps sharing their opinions. This is not what a mediation is. It's about empowering the clients to share their interests and the attorneys, again, to help the clients become informed so they can make their own decisions. And a last point that I like to advise mediators if they're going to choose this type of mediation, I like to have an informal memo shared between the lawyers and the mediator so I understand right from the get-go what in fact are the issues that are preventing resolution, and if there's anything that I should know going in to help shape the mediation, to help guide these clients, participants, so they can hear each other and start brainstorming in terms of options. Andrea, anything you'd like to add?
I mean, I was just going to say that, you know, prior to working with Helene on this presentation, my style always was to just do emails with the attorneys and ask them, you know, I would make a short blurb about what was the role of each party, the attorneys, the mediator, the participants. And then I would also ask them to send me a informal memo of listing all the things that are in this slide. And that has worked fine, but I have to say that after talking with Helene, I'm gonna try the conference call and see how that goes. That might be even better. So, but it's really a personal style thing.
The only thing I would add, thanks Andrea, is that, you know, if you're gonna get on the conference call with the attorneys, we really want to try to get a mediation date sooner than later. Some of the challenges the mediator has is getting that mediation date. And then, it becomes frustrating not only for the mediator, but for the clients. They know they're going back to court. The judge wants to know that they've been involved in mediation. So if all possible, if we could try to be flexible, it will give the clients more trust in this process if they know that we could all get on a mediation conference sooner than later. Wouldn't you agree, Andrea?
I haven't had trouble getting a date through emails, so
That's good.
I think it's really a question of personal style. So, and also just one quick thing is that the difference in private mediation, we go in with a clean slate. And Helene did make the point to me, because I was saying, oh, you get all that information. I didn't get all that information either, because I went in with a clean slate. And she said, well, it helps bring her up to speed. So you don't spend time getting up to speed with where you're at in discovery. And I think that's valid. So I might start asking for all that information in advance too. There's pros and cons. It's good going in with a clean slate, not knowing anything. And then again, it's good saving time by getting up to speed. So I was going to move on to the case study, if that's okay.
Let's do it.
Okay, so I'm just going to pretty much tell you the case study, ask what's wrong with the picture. We're going to answer the question ourselves. I'm going to start off by saying one thing about what I think needs to be done, and then Helene will carry it on. So, but anyway, here's the case study. So first you have to assume this is in a vacuum. I mean, assume everything else has been settled. There's no more financial questions, and whatever gets decided on this house issue is not going to impact anything else. So try to just think about these facts only. So spouse A wants the house. Spouse B does not want it, wants to sell it, and spouse A can't afford to buy the other one out. Right? So number 3, spouse A says, and spouse A is speaking, because in mediation the clients are speaking. And spouse A says, well, what if I give you less than your 50% equity? What if I give you 30%? How would that be? And attorney B jumps in and says, that's not acceptable. That's not fair. Are you kidding me? And then starts, talking about why it's so wrong, emotionally, usually, or with some force, and then, the spouse B, spouse A's attorney answers, and next thing you know, they're off to the races and they're bickering as the clients sit there sidelined quietly. So what's wrong with this picture? So we could go to the next slide, which pretty much tells you everything. But the key thing that's wrong with this picture is that, for me at least, is the attorney B, who just jumped right in and said, that's not fair, never turned to their client and said, what do you think about that? And maybe client B would have said, I can live with that. So that's the key thing, is the attorney just substituted their sense of fairness for their client's sense of fairness and you got to check first. That's the most important thing in mediation, is it's your client that counts. And then it's your job to make sure they're informed and understand they're deviating from the law and make sure there's no flaws in their thinking. But if that's what's fair to them, it doesn't matter if it feels fair to the attorney. So
I agree, Andrea, and it's all, again, about empowering the client. I don't know how many court-based conferences I went to as an attorney, and I still go to, where the clients always feel they're on the sidelines, they feel marginalized. Nobody's hearing them. And that's the great thing about mediation. If it's done right, that they feel heard, and then they trust that the other spouse also hears them, and they can talk respectfully about what is right for their family, because nobody's going to know more than those two people sitting in the room what's right for their family. There's no judge, and there's no attorney that's going to know better than they do.
And I just want to say, I know we have questions from the audience, but there's one key thing I want to say about this: keep control of the process, which is, you can't be a fly on the wall as a mediator. You can't.
Andrea is not a fly on the wall.
Neither are you, Helene. So you can't be shy. So because a lot of times attorneys are used to keeping control of how things go. And some of them are not familiar with mediators. Some people question even mediation. But that said, you know, you have to be able to say, whoa, 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 hold on a second. I hear loud and clear. That doesn't sit right with you. Can we check in with your client for a second? Or I've had things where attorneys will say, I think what we should be discussing is, and you need to be able to say, I get that, we'll get to it, but I have a process. I've been doing this a long time, and this is how we're going to do it. So you can't be shy. So
yeah, and I want to say that sometimes when you get into this wrangling, it's because the clients, maybe they need some legal advice, they don't understand the law, which do play a role. And that's what's so great about the Zoom platforms that we're all working on right now, because we can create breakout rooms so the attorney and the client can have those conversations, and then we can get back into the room. Because if there's no understanding, meaning that the client's not informed, you don't really get that breakthrough, that understanding to move towards agreements that will work really better for the couple involved. I also wanted to mention that in this, at least the court-sponsored process, many times the attorneys are there for the first meeting, and which of course is encouraged, because we want to make sure that the clients feel comfortable with the process. But ultimately, what can happen is that the attorneys become more of a consulting attorney or review attorney, and their role changes, and they may not attend the second, the third mediation, but they are consulting with their clients, either before the mediation. Sometimes it could even be during the mediation, and maybe an arrangement between the attorney and the client that they'll be on standby call if the client needs to call the attorney. This is important because, as we know, legal expenses can pile up. So between mediation costs, attorney costs, we need to be mindful of that for our clients and let them know that mediation can work with attorneys in the room, but it also can work without attorneys in the room, as long as you're feeling supported and getting that legal advice that, of course, you need to make informed decisions that are going to be durable for the future.
So I just want to jump in really quickly. We are a little past 1:30. I'm going to let the attendees know we're getting your questions. We're going to address your questions. So we're going to stay on a little longer. Hopefully you can stay with us. If not, we are recording this and you'll be able to access the questions in the archived version, which we'll send out to you shortly. Do you want to just jump to questions at this point, or do you?
I'm ready to go with questions. Andrea, anything you want to conclude with?
Oh, that's good. We can go with questions.
Okay, great. So and some of the questions you were kind of answering too as you were giving your presentation. So we have somebody asking though, do you ever insist that attorneys attend every mediation?
No, not me. I may insist in private mediations when there aren't even attorneys in the room that the clients, rather than wait to the end to get an agreement reviewed, I might insist that they have a consulting attorney along the way. I have not had a situation yet where I've insisted that attorneys come, but I could see a situation where it would, if there's, you know, for the mediation to continue at least, if someone just needed that kind of support, they just couldn't participate.
I agree. I don't insist, but if I see that there are large power imbalances, I think it could help to have an attorney in the room so the client can feel supported in that way.
Just to make the point that there's a role for everyone, and whether the attorneys are in the room or on the side consulting, it takes a team effort in this process. It takes the attorneys, it takes the mediator, and it takes the parties for all
Absolutely, absolutely.
that finish line.
So we have somebody asking, can you speak to the strategies to manage attorneys who are not convinced of the mediation's value and are reluctant to actually give up potential revenue? How does that usually work?
Right. Well, I mean, I could say that there's revenue in mediation, as we just said. You know, you need consulting attorneys, you need reviewing attorneys. So I don't know if, I mean, if the goal is to help a family resolve their divorce issues, as you know, and keep their family as intact as possible, especially with their children, this process has room for everyone to make revenue. But whereas litigation often results in people getting further and further apart, and this process usually brings people closer and closer together. And I forgot the other part of the question, but maybe Helene knows.
Well, I'll just say that somebody who does both, that the attorney has a very big role in complying with the discovery orders that the court has promulgated pursuant to the preliminary conference. And the mediators, depending on the attorneys, making sure their clients share that information. And that discovery compliance is a very large revenue generating task. So don't think they're going to lose any money in that way. But I also think the reality is, and most attorneys know this, that clients are very overwhelmed and frustrated. They only have a limited amount of money. They pay their retainers. They're afraid their retainers are going to be depleted. And so we need to be real about the money that our clients have and support them to get to the end of this process. So I don't think anybody's being cut out. I just think that we're there for our clients and serving our clients' needs. And we need to be mindful that not everybody has unlimited budgets.
And for those who don't have unlimited budgets, I mean, we're fortunate that FamilyKind does offer divorce mediation through the court now, and also on their own privately with a sliding fee scale, so that can help the cost. But I remember the other part of the question about attorneys who are reluctant about mediation. And what I wanted to say about that is, you know, I would imagine then they're just reluctant about it in general, because whether they get forced to do it through the court program, or they just think maybe if they were convinced this might be a good process for a client who works in their office and they would be the consulting attorney and so forth. You know, you can't guarantee anything in law in general, and certainly in family law, you don't know how it's going to come out. And to go all the way to a trial is highly unlikely. That doesn't usually happen. And what I tell people who are reluctant about it is, like, it's not a way to hide assets or anything like that, because any good mediator will not let a mediation continue of anyone who's hiding assets. But but since there's no guarantee in how a decision would come down, if you think about it, you think all the legal arguments you have, well, now put yourself on the other side, and now you're representing the other side. What are all the legal arguments you have for them? So you know there's legal arguments on both sides, and there's no guarantee. So that's what I do in mediation. When people start arguing the legal arguments, I let it go for 1 or 2 rounds, and then I say, clearly you could see your attorney has legal arguments and your attorney has legal arguments, and you don't know how it will come out, but you're not in court, you're in mediation. So what do you want to do? And it's on the parties to make the decision of, are they going to go and battle it out in court, or are they going to figure out where they can give and take and come up with something that they both can live with? And I mean, the answer to that question about the reluctance of the process is, there's no guarantees in litigation. And at least in mediation, the parties are making the decisions.
And I would just like to add, I think those are really great responses. Mediation, what's happened in the room is so important during that time, but it also gives and empowers clients to see that they can communicate, they can hear each other, and hopefully giving them skills and strategies for after the process. So that's another important, way that a mediation can help, and that lawyers could be happy about, because sometimes it's even difficult for lawyers to handle their clients because they're so, upset, and they just have, they just want to say destroy the other, their spouse at that time. So there's sort of a lot of positive things about it for all the professionals involved as well as the clients.
So we are getting a lot of questions. So what I'm going to ask is so that we can try to, and I think some of your answers have covered some of the questions, but if we can do sort of more of a rapid fire response and then see where we are by the time we get through the questions. This way we can get to more questions. That would be great. So let's see. So you talked a little bit about using Zoom technology so that the attorneys can use the breakout rooms to share various things. How does that usually work? And are there other ways, like this person's asking, you know, maybe the party is uneasy talking about something in front of the rest of the people in the room, or the attorney wants to say something privately to his or her client. How does that usually work? Does somebody say, we need to have a timeout and go into a breakout room? And are there other ways you're utilizing the breakout rooms?
Well, in my practice, I use the breakout rooms sparingly because we have a limited amount of time, but I let everybody know that that is an option. And if the attorney needs to counsel their clients, either to give advice in terms of strategies or legal information, then that's what the breakout room is supposed to be for. If it's a more comprehensive conversation, then they may just ask to adjourn the mediation, but it shouldn't be for a long standing conversation. It just should be just a check-in with one another so the client is empowered in terms of advocating for themselves in the room.
Okay. So we also have somebody asking what if the attorney perceives the mediator as someone to be won over to their side? How does the mediator deal with that? And are there some kind of tools and techniques for dealing with that situation?
Well, I mean, I could say, you know, I mean, I'm not quite sure how that works out. I mean, the only way it's ever shown itself to me is, you know, an attorney saying, am I right? You know, and looking to me. And I mean, an attorney or whether it's a client, I just said, it's not, you know, that's not a question for me to answer. I just deflected. I say, it's that, you know, that's not a question for me to answer. And I'm not sure it's a question about right or wrong. That, you know, it may be the law. The law can be interpreted in different ways. What's important here is what's important to your client and what's important to the other clients. And I try to get it refocused on that. I just try to refocus it. But I never, ever, I mean, I won't write. I mean, my God, the other attorney will walk out the room.
Right, you know, our job is to be neutral third parties. We don't give legal advice. I'm sure Andrea does this. We make sure everybody understands what our role is. We're not there to confirm anybody's legal opinion or strategy. We're just there to make sure everybody is heard. And we're not there to give our own advice, so.
If they're asking me a factual question, like, well, the CSSA says, you know, the child support law says that it's 17% for one child, am I right? I mean, I would say, well, if you ask me what the law says, yes, this is what the law says. But I mean, my hope is that before we got onto child support, mediators lay out what the law is. We give information. So I would have said what that is. So, I mean, something like that. But if they're asking me to agree with them on a question of opinion, it would take neutrality. You can't do that.
I agree.
So the other question that we're also getting is that, and it's something we talked about during the rehearsal, that, you know, it might be the parties may be interested in taking less than what they deserve, but an attorney is saying an attorney would not want to let the client take less than they deserve. And I know we talked about this during the rehearsal. So if you could just address that issue a little bit.
Right, so there's the concept of legal rights versus the client's interests. So the client could always choose to take less, and I use that word in quotes because that means different things to different people. The point is, as long as it's an informed decision, as long as the client has the advice of the attorney, then it's the right decision for the client. And we all No, as attorneys, we can write into our agreements the fact that the client had the information and they made that decision based on the advice provided. So the attorney's protected and the client gets what they need for them to move forward and feel that their interests have been protected and preserved.
Yeah. I want to say a couple of things about this because this is like, we're trained to be steeped in like adversarial, pursuit of legal rights, right? And as opposed to a mediation, the hope is everyone's steeped in conflict resolving skills. And so it's ironic because, the rights-based arguments is very different from the interest-based arguments. And it creates this irony in mediation where, the mediator focused on interests can find themselves at odds with the attorneys who are focused on legal rights, yet they're the people that the participants hired to help them. So there's like a little twist in there that's a little ironic to me. But again, yes, I mean, the mediator, I would say if that was happening, when I said before, you can't be shy as a mediator, I mean, I have said it to attorneys. I get that that doesn't sound fair to you, but your sense of fairness is not what's paramount here. What's paramount right now is your client's sense of fairness. And it may be a deviation. And, what's important is what is their underlying thinking? Is their thinking, are they aware it's a deviation? Are they aware of the law? Do they not care? Do they say, yes, that's okay, and I can survive on this, and you reality test it, and it's something that would work for them? It doesn't matter. The attorney has to basically suck it up in some ways. I mean, I don't know if that's the right term, but I mean, their job is to support their client's sense of fairness, not advocate their sense of fairness in place of the client's.
So we're having another question about if the mediator sense the attorney is actually trying to take over and derail the process. How do you handle that? Do you do a breakout with the attorney in one of the breakout rooms? Do you ask them to leave the session? How does that go?
Well, I mean, it depends on, how they're demonstrating. I think, as Andrea said, you have to take control of the room. You reiterate what everybody's role is. And my mediations and most mediators will remind everybody that we need to be respectful of one another, not interrupt one another. Many mediators will have, well, before COVID, we had pieces of paper and pens in the middle of the table where you could write notes and understand that everybody has their own turn. So it's just a matter of taking control and reminding people that they're there for a reason. And ultimately, nobody's looking to embarrass anybody. But if it comes to pass that after that mediation that the attorneys just can't, understand what their role is, you have to question whether the mediation is right for these parties. I think I would feel comfortable sending an email to the attorneys to perhaps have a short conversation about how it went and what everybody's expectations are. Because it seems if the attorney can't understand their role, then the mediation is just going to fall apart ultimately.
And what about the role of the AFC in the mediation room?
Couldn't hear you, Patty. Can you repeat that?
What is the role of the AFC in the mediation room?
The AFC, in my experience, I've always invited the AFC. Sometimes they come, sometimes they don't. But I think, obviously, particularly in parenting issues, very important to understand what the role, rather what the wishes of the kids are, whether they have particular needs. They are an integral part, the children, in obviously custody and parenting issues, and I always welcome the AFCs. And again, sometimes they appear, sometimes they do not.
For me, being that this is a relatively new program, I haven't yet had a case with an AFC, but I would welcome them too, for sure.
Then a couple of last questions. So we have somebody asking if the judge is pushing the attorneys to get the settlement done, or else the judge will put the case on the trial calendar, how should the mediator respond? And part two is it ever appropriate for the mediator to participate in a court conference with the attorneys?
Well, in my experience, the judges do not want the mediators to participate in any type of court conference. The processes are really separate, and in both Kings and New York County, they are managers and liaisons of these presumptive divorce mediation panels, and you basically would advise the manager of that program where you are in the process. Sometimes the mediator might ask the manager to advise the court that maybe they can push out the court date because the attorneys and the parties are really working hard to try to resolve it, and they have a lot of pressure about coming back to court. So I have used the court staff in that way, but in my opinion, I think most judges would agree it's not appropriate for the mediator to be there. They want to know, is it resolved, or if it's not. If you need more time, most judges are open to that because we really all do have the same goal in mind. I hope that answers at least some of your questions.
I have nothing.
And so I think we've covered most of the questions. Thank you, everybody, for sending in your questions and comments. I'll give each of you a chance, if you wanted, in 30 seconds, just one key takeaway or one final thought for everybody. Why don't we start with Helene?
Well, my final thought is, especially in a time of COVID, the opportunity to mediate your divorce is such an important opportunity and tool. The courts have so many challenges in front of them now, and if we can offer our mediation skills to the court system and get the trust of the attorneys to value this process, I think we will all be doing our clients a great service. Thank you.
Andrea?
I just think it's a great opportunity for attorneys to take hold of the origins of our profession, which was to be healers and settlers of dispute. And mediation is such a great vehicle for that. And I think it's great. I really like it. I like the court program because I really like mediating with attorneys in the room.
And Leslie, I'll give you the final word.
Right. So I just want to say, I found this topic very, very interesting. And I've actually learned quite a bit from it, because at first I was kind of skeptical, having attorneys in the mediation room. I felt it would be a clash, maybe they would try to take over because it is such a different process. But the more I'm thinking about it and hearing from our presenters and all of you, I do agree that this could be a great opportunity for maybe the attorneys to understand more what goes into the mediation process, and for all of us to work sort of hand in hand for the benefit of our clients.
Well, thank you. So again, thank you, Leslie, Helene, Andrea, and all of our attendees. Also, thank you to our sponsors, SoberLink and Our Family Wizard. We had a lot of great discussion today and a lot of good information shared. I have a feeling this will be an ongoing dialogue. Our next peer-to-peer webinar will be on Monday, September 21st, so mark your calendars. And of course, if you have any questions about FamilyKind, please go to FamilyKind.org. And of course, we are a nonprofit organization that offers services with the help of sponsors and donations from families and professionals such as yourself. And that's how we're able to provide things on a sliding scale fee. So feel free to visit FamilyKind.org/support, and if you were inclined to help. Thank you, everybody, and have a great day.
So long. Bye-bye.
Thank you, Patty. Thank you, everybody. Take care.